Changes to Michigan's Marketable Record Title Act are coming into effect at the end of March. What does that mumble of words mean? It means that you may need to take some extra legal steps to preserve certain rights or restrictions that were previously baked into the deed of your home.
Originally, the statute was going to be in place a couple years ago, but with COVID and with the request for amendments, it was extended to 2024.
If you have certain restrictions or access rights written into the deed of your home property, you may need to act ahead of March 29th, when a number of amendments to our Record Title Act take effect.
People don't need to be anxious about this, but it is a good thing to become aware of. If they can go back and find their deed and see how they took title to their property, or find their title insurance policy.
When you purchase property, there will often be what are called restrictive covenants placed on what you can do to the building or land. A restrictive covenant is defined as clauses that prevent, prohibit, restrict, or limit the actions of a person or entity named in a contract.
Things like building size requirements, certain setback lines, what you can use your property for and not use your property for.
Sometimes these are recorded in the deed using specific language. Other times, more generic wording will be used, such as,
I'm conveying to you X parcel of land together with all easements and restrictive covenants, or all easements and restrictions as may be recorded. Well, that's not exactly defining the specific restrictive covenants that might have been put against the property back in 1970.
If that is your case, you'll need to seek out a real estate attorney to file appropriate documentation to ensure any covenants are preserved. The new changes say that if left ambiguous for over 40 years,
they may no longer be applicable to that buyer, which means that those restrictive covenants are no longer necessarily applicable. And so if you live in a community in which the neighbors and the HOA folk all want to abide by those restrictive covenants, something needs to be done to preserve and protect them.
So if you are past or near that 40-year mark, you should look into the possibility of having someone familiar with real estate law look over your deed to see if further action is necessary.